Fictitious tax credit at the Indonesia Export Financing Institution (LPEI) criminal act
bahwa
of
pada
corruption.
tanggal
The case of
23
alleged
Desember
corruption related to the provision of
2024,
credit facilities
KPK telah
by the Indonesia
menetapkan
Export
Saudara HK
Financing Institution
sebagai
(LPEI)
tersangka
has attracted public
berdasarkan surat
attention
perintah
due to
penyidikan
its significant
nomor Sprindik
impact
152
on state laws.
dik titik
Below
00
are details regarding
01
the case as investigated
12
by the Corruption
2024
Eradication
tanggal
Commission
23 Desember
(KPK).
2024.
Background of the case: LPEA, also known as Indonesia Exim Bank, was established to support national export financing. However, in its operation, there have been allegations of irregularities in the granting of credit facilities to several debtors, leading to substantial state loss. One of the major cases involves PT Petro Energi (PTP), despite having a current ratio of less than 0.86 indication for financial health. LPEA still provides credit facilities to the company. Furthermore, PTP is suspected of falsifying documents such as perhaps order and invoice to withdraw credit and using to fund for purpose other than their intents as state loss. As a result of these practices, the state is estimated to have suffered a loss of approximately the $60 million or around 900 billion just from the PGP case involving 11 debtors. To the potential state loss amount to 11.7 trillion. Legal action: currently, legal proceedings against the suspect in this case are still ongoing. The Corruption Eradication Commission (KPK) has named 5 suspects, including 2 LPEA executives and 3 executives of PT Petro Energi (PTP). On March 20, 2025, KPK detained 2 suspects, namely James, President Commissioner of PTP, and SM, the director of PTP, for an initial 20-day detention period until April 8, 2025. If found guilty, the suspect could face up to 20 years in prison and fines amounting to billions of rupiah. However, as of now, no court ruling has been issued with a definitive sentence for the suspect. Asker. My opinions: if the suspects are proven guilty in this case of fictitious credit at LPAA, a maximum sentence of up to 20 years in prison and fines amounting to billions of rupiah can be considered quite fair. Given the extent of the state losses incurred, this case involves corruption allegations that have caused the country to suffer a loss of 11.7 trillion, a high amount with the potential to hinder national economic development. However, the effectiveness of the punishment does not solely depend on the length of imprisonment, but also on whether the lost state fund can be fully recovered. If the perpetrators are only imprisoned without significant asset recovery effort, then the punishment might not provide enough deterrent effort and just for the public. Therefore, the punishment can truly be considered fair if 1. The perpetrators receive penalty proportionate to the damage they have caused, and the corrupt fund and assets are fully recovered and returned to the state. If these conditions are not met, the punishment given may still not be strict enough.